Today we'll be talking about land title documents you should know about. So long time back, long before horses had legs, in Nigeria, land ownership was owned by specific types of people. Very rarely could you find individuals owning landed properties in the time past here in Nigeria. Land was owned by title chiefs, by traditional rulers, or by the general community. Right? So for this type of land ownership, let's now talk about land tenure system, right? But the land tenure system had some challenges, right? So as preferential treatment, not until the advent of the Land Use Act of 1978, then Land Use Decree of 1978. But to cut the long story short, what that decree meant was that all landed properties in the country automatically became the property of the government. So if you're in a state, all land in that state becomes the land of the governor. The governor now automatically owns the land. But if you're in the FCT, of course, it automatically becomes the property of the president. When the government took over ownership of all these landed properties in the country, this process is what is known as government acquisition. This government acquisition has to do with the government. It doesn't have to do with you. We're looking at the title documents that have to do with you and I as individuals. So government taking over a parcel of land is known as government acquisition. So I'll give you an instance of Chief Obafemi and his family. Chief Obafemi and his family were one of the families and chiefs that the government took over all their properties. Of course, every property in the country was taken over by that Land Use Act. Okay, but because the government is considerate, the government now admonished these landowners to seek redress in court. Right? So what Chief Obafemi and his family did was they got in touch with their lawyer, and then together with the help of their lawyer, they petitioned the government. And then they said, I, Chief Obafemi, the son of Chief J.K. Taiwo, I claim ownership of the 600 hectares of land in WWK community of XYZ state. The land has been our family land right since Ojukokoro. Right since Ojukokoro. When our forefather, Chief Femi Taiwo, stepped foot in this location, every parcel of land as far as his eyes could see became his own, because there was nobody here in that location in 1900. So, down to at the point of his death, his son, late Chief Tunde, inherited that property, and it has been passed down from generation to generation down to my very self, Chief Obafemi, which I'm going to pass down to my sons. You cannot take away my 600 hectares of land just like that. Give me my land. And now the government will look at this and say, okay, this is what we're going to do, Chief Obafemi. Out of the 600 hectares of land, we are going to carve out 300 hectares and give back to you and your family. So with that 300 hectares, you can do whatever it is you want to do. You want to sell it, you want to develop it. But do not encroach into our own 300 hectares. You must only make use of your own 300 hectares. That is what we're giving back to you. And then the case is settled. This act of the government carrying away 300 hectares back to Chief Obafemi and his family is what is known as excision. So excision simply means carrying away from a part, taking away part from the whole. Okay, excision. And after the government excised that 300 hectares back to Chief Obafemi and his family, they are going to write it down on an official government record book. I'm going to say 300 hectares have been returned back to Chief Obafemi and his family on so day. That 300 hectares is located at WWK location in XYZ town. On so date, it has been returned to Chief Obafemi, and they stamp it. And then they publish it in the newspapers, the magazines, and all of that. So that record book that the government has now recorded that excision is what is known as Gazette. The Gazette is therefore the official record book of the government where all these landed property transactions or excision are being recorded. Then after that, Chief Obafemi and his family will now go and, through the help of a registered surveyor, carve out that 300 hectares of land and create what is called a survey plan. The registered surveyor is going to create a survey plan, and what that survey plan does is that it marks out the entire boundary of that land. The survey plan shows you the exact boundary, it shows you the entire description. So a survey plan is a document that shows the accurate description and boundary of a land. Now, I always recommend if you want to buy a land, ask for the survey plan. It is with that survey plan that you can take to Alausa, and every single detail, the history about that land will be drawn out. Okay, the system will bring out everything you need to know about that land, from the ancestral owner down to the current owner. The survey plan will also help you know if that land is meant for residential or agricultural or commercial layout that the government has already planned out for that location. So you don't go and buy in an area that is designated for agricultural purpose, they want to go and build your own house there. It's not going to work. So after Chief Obafemi and his family have drawn out that survey, they need to register it so it becomes a registered survey. So now we'll talk about the deed of assignment. The deed of assignment is one of the most important documents you should have after a land transaction has been concluded. Okay, so the deed of assignment is an evidence that shows that the seller of that land has transferred all his rights, all his interests and ownership from himself to the buyer. So the deed of assignment also gives pertinent information about that particular land. It tells you the location, it tells you the size, it tells you the date that the transfer of ownership was concluded between the buyer and the seller. This deed of assignment can also be called deed of conveyance. In the past, it was called deed of conveyance up until 1978 when the Land Use Act was enacted. So if you are hearing deed of conveyance, don't be confused. It is still the same as deed of assignment. So what it simply means is that the seller, that is the assignor, who is the seller, is transferring all his rights, all his interests, his ownership of that land from himself to the assignee, who is the buyer. Deed of assignment. On to the next one, deed of lease. What is lease? Lease is just the senior brother of rent. If you're paying for an apartment for 1 year or 2 years, you're paying rent. But if you're paying for more than 2 years, it's no longer rent, it is called lease. So the deed of lease is a document that shows you are leasing that land for a specific term, most times between 35 to 70 years. So the difference between the deed of assignment and the deed of lease is that in the case of the deed of assignment, the owner is transferring all his rights, all his ownership rights to the buyer. He is no longer the owner. He has assigned everything to the new buyer. While the deed of lease is simply telling you that you are not the owner of this property, you are only giving it to you so that you can use it for a particular time, after which it comes back to me as the original owner. Can we talk about the JV, the joint venture agreement? What does it mean? You have a land, but you don't have money to develop that land. I have money and I'm looking for a land to develop in a particular area. So I come to you that has that land that I'm looking for, and you bring your land, I bring my money, and I develop a property on that land, and we sell for profit. Easy peasy. Lagos is just so sweet. That's why it is the commercial hub of the country. You don't have money, you have land. I don't have land, I have money. We come together, we develop that land, and we sell for profit, and we split the profit. So we don't share it 50-50. This is where equity comes into play. The major parties you're going to find in the JV are the landowner and the investor. Next is the deed of debt settlement. Mr. Mango has been owing Auntie Tomato for a long time, but Mr. Mango does not have money to pay Auntie Tomato. But Mr. Mango has a property on the island, on Banana Island, that he wants to use in paying Auntie Tomato. So what the both of them do is that they come together with their lawyers and they draw out a document that will state clearly that Mr. Mango is paying anti-tomato with that property. So that document they will be signing is what is called the deed of debt settlement. After signing it, everybody goes their own separate way. Nobody is paying anybody any longer. Now let's talk about the contract of sale. I'll also use this opportunity to create this misconception about the contract of sale. The contract of sale is not a title document. Contrary to popular belief, contract of sale is not a title document. You cannot use a contract of sale to go and say you are applying for a C of O. No. The contract of sale is simply a document that clearly states out the terms and agreements between the buyer and the seller of a property. For example, I want to buy your property. I'm giving you terms and conditions for buying your property. But you want to sell your property to me, you are giving me terms and conditions for me to buy that property. For example, I'll tell you as a buyer, I'll come to you and say, okay, I'm paying so amount of money for this property upfront. But after payment, I will move in or take possession of that property. If nobody comes to drag ownership of that property with me after so time, then I pay you the balance. Or you as a seller, you are telling me in that contract of sale that if I do not complete payment in 6 months' time, I'm going to refund you your money and take back my land. Or I'm going to sell that land to a more serious buyer and give you another different land somewhere else. So all these terms and agreement is what is found in a contract of sale. A contract of sale does not prove that you have bought a property. However, if you're buying a property and what they gave you is the contract of sale, you have no reason to worry, especially when you are still paying for that property, when you have not finished paying. All you need to do is to find out when you're going to get the subsequent document that is going to prove you finished paying and the land is now yours. Most times, these real estate firms give out this contract of sale because most of the transactions are subject to terms and agreement. So if you are buying a property and what you have is the contract of sale, you are in order. All you need to do is to find out when the main documents will be handed over to you. Most times, these real estate companies are also trying to perfect their own documents on that property. Now we're talking about the genuine ones. But I'm going to cover up some of these fake real estate companies in Lagos that keep streaming people here and there. I'm going to drag them like tiger generator. You see, that's why the Lagosians need to be careful. The watchword here is due diligence. Due diligence before buying property. So let's talk about the deed of gift. The deed of gift simply means it is a document that proves that the property has been gifted from one person who is called the donor to another person, that is the donee. Now, a quick break. Remember last year when Kiss Daniel bought 2-bedroom penthouse apartments for each of his twin babies? Did you notice that the names on the documents were the names of his babies and not Kiss Daniel's name? So those of you whose husbands will buy, should we shatter the table? Let's shatter it. Those of you whose husbands will buy you properties, will buy you a property, and then the name on the document is his own name, not your own name. Should we tell them the truth? Let's tell them. It is not your own. You are only managing the property for him. Yes, now. So the deed of gift is a document that proves that somebody has gifted that property. It is no longer the person that owns it. It is now coming as a gift from one person to another. That document is called deed of gift. Let's talk about the branch of probate. When you inherit a property and you have evidence of that inheritance, probably in a will, and you now wish to be recognized as the legal owner of that property, you are known as an executor of that will. So what you need to do is to apply, either in person or through the help of your lawyer. What you do is you get a letter of administration. Once it is approved, you'll be signing a document known as probate. Now let's talk about the C of O. What is the C of O? The C of O is the certificate of occupancy. This is arguably the most important title document here in Nigeria. It is issued by the government to prove that that person has been granted the statutory right of occupancy on that land. The statutory right is usually granted for a period of 99 years. After 99 years, your C of O expires, so you don't have to apply for a new one. However, this is mostly in theory. In practice, Very rarely will you see somebody that is going to be applied for a new CFO. But it is important to note that the government can only grant one CFO to a particular parcel of land. Next is the governor's consent. What is the governor's consent? Now, the government cannot grant two CFOs on one particular land. CFO is granted once and for all. If you are buying a property that already has a CFO, you know the name of that CFO is not your name, you are buying it from the owner, and you want your own name to appear, what you need to do is to take that CFO and apply for a governor's consent. What the governor's consent simply means is that the government is recognizing you as the new owner. You are buying that property from the person that has the CFO. If it is not a property with a CFO, you don't need to apply for a governor's consent. The governor's consent only comes when you are buying a property with a CFO. If you are buying a property that has a CFO, make sure the person selling to you is the person's name that is on that CFO. Let's say I apply for my own CFO and I'm granted the CFO. I now sell to Mr. Jude. But Mr. Jude did not apply for a governor's consent after buying from me. He now wants to sell to you. You need to make sure it is Mr. Jude's name that is on the CFO. Because if you go to apply for a governor's consent, the governor does not recognize Mr. Jude as the owner of that property. The governor still recognizes me as the owner of that property. So what they'll ask you to do is you're going to pay for Mr. Jude's governor's consent before paying for your own governor's consent. So you need to know if the person selling to you is actually the owner of that property by means of identification, as his name is on the CFO, and then you also need to know how long it will take for it to expire. So when you're buying a property CFO, you need to know how long it will take for it to expire, and most importantly, you need to know if the person selling to you is the person that has his name on the CFO. So you don't pay for a governor's consent twice. If you get value from this video, don't forget to like, don't forget to subscribe to this page. Cheers.